May appeal also. I beg to mention for listing one IML for suspension of sentence, my lord. Respondent also filed, a respondent also filed objection, my lord.
চাই দিব
Okay.
নেক্সট নেক্সট দি দিব
For orders, item number 1.
May please, your lordship.
Lordship, in terms of another court order, we received one communication. I think we have already submitted.
This is regarding that public prosecutor issue.
Oh, yes, yes.
First communication we didn't receive. Regarding the appointment of special PP, there's a notification.
Number is not there.
Your case number is
My case number is, my lord, special case, POXO case number 5 of 20.
5 of
20.
20.
20.
And trial continued from
Trial started.
Charge framing,
on
charge framing,
February of 2022. and
charge
yesterday.
framing.
My lord,
No, 1 minute, one by one.
My case, my lord, charge was framed on 25/2/2022.
25
2022.
2. And judgment
Judgment, my lord, at 24/8/2022.
February 22 to
August 24.
August 24.
August 24.
And this letter is of
2021, my lord.
21.
24.
September
21.
2021. September 2021. And this situation continued up to
Up to 2023, my lord, till Nandita Basumutari was appointed as public prosecutor. There is one communication, my lord,
so your case ended in between.
in between, my lord.
And what about your case? Your case started
My charges were filed on 22 February 2022.
February 22, like
Same.
you. Then
Judgment was passed on 31 2022.
20.
30 January 2022.
Thereafter, this MS Basumutari was appointed.
Appointed.
Thereafter,
Lordship.
Miss,
So during that period, Daniel Das was without case diaries. Prior to commencement of your trials,
here,
yeah, late.
he was virtually stripped of the
power.
power to conduct
Trials.
trials by directing him to submit all the case diaries. That is the situation. Thereafter, trial proceeded
Proceed.
with 2 parties only.
2 parties.
Others might be there, but they have not come before this.
Witnesses are coming. Who are issuing summons to witnesses?
Oh, bench assistant, madam. Bench assistant. They are being examined as prosecution witnesses.
The bench assistant is playing a part of public prosecutor. Appointed special public prosecutor, a statutorily appointed, has to conduct, because CRPC public prosecutor is okay, but POXO is a special act, and there is a provision for special public prosecutor. And for the government, there is an obligation to issue separate notification. That notification is there, but the man is not there. Because of this situation, perhaps.
If your lordship permit me, I'll just point out one thing. If your lordship has my appeal memo, my lord, item 1.
page 73. And the way the trial was conducted, page 73, 73. Lordships has it. So my lord, in this case, learned public prosecutor has not appeared. So that is absent. 22/4/2022. Now, my lord, page 97 is the evidence, corresponding evidence recorded on that day. Oh, yeah, right. Appeal memo. Lordship has it. This is the evidence of the MO, recorded as a prosecution witness. Now, my lord will kindly turn to page 108, 100, sorry, 100. Questions put by the court. So distinction has been made by the learned trial court. Here, as a court, the court is examining the witness. And yet, in the first part, this witness has been examined as a prosecution witness, as if somebody was appearing in as a prosecutor. If the entire evidence had been recorded under 165 Evidence Act, as questioned by court.
100 can be done under 165.
5, yes, ma'am.
No part,
Yes.
no issue.
But
These
this is-
questions can be asked.
Yes, ma'am.
But the
Preceding
first part is,
yes.
preceding part is,
That is the mode in which the entire trial was conducted.
now you please prepare 1 or 2 pages, bullet points. Otherwise, it will be very difficult to.
Because we on the last occasion we had submitted a compilation of the case record. If we are able
Case
to take
record,
it back,
no,
my
no,
lord.
only,
Yes.
huh?
If we are able to take it back, we'll give a compilation for your lordship's convenience.
Okay. Which one? In your case,
In my case, ma'am.
this one,
Yes, ma'am.
I think this September 2001 preceded both the cases.
Both the cases.
And appointment of MS Bosumutari succeeded both the cases,
Yes.
right?
Yes, ma'am.
This
Ms.
note
Bosumutari was
down
appointed.
so that your trial comments, your trial ended, Charles framed that this list of dates, list of dates, both in both the cases separately, so that we can find out. Have you found that, Denning? No. There is a famous paragraph from Lord Denning.
Dennings. And it's
Lord
57
Denning.
Lordship quoted
Next
there.
date I will.
Try to find out, my lord.
Judge
Yes.
donning the role of
Yes.
prosecutor, aptly.
My lord.
But you must bring both this by 1-page affidavit in both the cases, this order.
Yes.
This order today you have just pointed out, this one.
Today's communication.
This chief administrative officer passing an order as per the direction of the district and session judge. It is not there. Is it there? No. 149 is in response to this. Have you seen this? Have a look, have a look.
There is no reference as such.
Have a look then.
Again,
Now this will complete the
my lord.
state of affairs.
Mhm. 2183.
Reference to it, my lord.
It is, as directed by.
So it indicates that direction was from the district and session judge.
If I may pray, my lord, along with this special PP, a PP being appointed as special PP may also be brought on record. That notification also.
Lordship.
Which one, where it was referred?
My lord, this one, my lord, order dated 3rd of August 2013.
Appointment of special PP.
Where is that? On that notification.
Notification.
Right, right. Miss-
Lordship,
Miss-
under raised to be directed to a obtain a report from the district session judge if any direction is of the district judge is available with them. Or it was just a verbal order.
That may not be.
Memo number.
This is there, perhaps this is
Something must be there.
this perhaps will
Okay.
suffice, my lord, since it is there on record.
We will just indicate if possible as directed by the district engineer. Oh. Get out right in the Twitter. Oh, so he go here.
Most likely, my lord, as directed, since it's given as directed, if there had been some notification,
It have
generally
been
the.
issued by Chief Administrative Officer, Office of the District
Right.
Session Judge.
He is basically Sirastadar.
Yes, sir.
Now, new
Now-
designation, new nomenclature. নাম কেইটা বেলেগ বেলেগ কৰি দিব খালি প্ৰথমটো ক্ৰিমিনেল এপিল এছ নৱাজ হা Heard Mr. S. Nawaz, learned counsel for the appellants, appellant. MS B. Bhuya, learned senior counsel and additional public prosecutor for the respondent number 1, State of Assam, and MS L. Devi, learned legal aid counsel for the respondent number 2. Full stop. Para. MS Bhuya, learned senior counsel and additional public prosecutor, has submitted that a copy of the order under memo number itu চাই লব DJCH লিখা আছে V end হৈছে 2185 dated 23/9/2021 has been received, and from the said order it transpires that the Chief Administrative Officer O/O, the District and Session Judge Sirang Kajolgaon, had passed that order as per the direction of the learned District and Session Judge Sirang Kajolgaon. And by that order, the learned additional public prosecutor was requested to submit all case diaries as per the list attached therewith to the office of the District and Session Judge Sirang Kajolgaon. Full stop. You filed affidavit in both the cases.
Lordship.
You extract that list from there, put it here also in the
Extract the
next
list.
affidavit. In the next affidavit.
Yes, extract the list of
That's
case
the
diaries.
150, 150 of your affidavit
Lordship.
or internal page
Yes.
for our benefit,
Yes, my
so that we can should not go here and there. That internal page you have
Lordship.
annex are 4,
I will.
right? MS Bhuya has sought a week's time to bring the said order along with a notification. Next page was a bearing number, memo number, JDJ, dated 3/8/2023, on record by way of an affidavit. Post. Para. as it transfers from the order under numbers DJCH, dated 23/09/2021, that the said order was passed as per the direction of the learned district and session judge Srirang Kajalgaon, registry to ascertain existence of any such direction, and as to whether if in writing. If it is not writing, then verbal. This will be done by registry. First of a judicial, it's a judicial, a copy of this order. Along with the along with a copy of the order dated 2/9/2024 be brought to the notice of the Registrar Judicial for taking necessary steps from his end. So he bring this to an affidavit, this order. Registry will ascertain, written next Friday. Mr. Ahmed, your case is same will do. File both in both the affidavit.
Yes,
Same, only A. Ahmed will be there. LDB will not be there. LDB is there? No.
No.
LDB will not be there. You say? Appellants. Next to item number 2. Appellants. If I could remember, in your case, I don't know whether it will be mistrial or retrial or something, or acquittal or conviction. But question is that in that your case, the vital witness, vital witness said something in the evidence in chief, then there is a long adjournment. Then he subtly changes his version in cross. Now, at that point of time, the session judge was helpless. He cannot declare him hostile. After cross examination also, prosecution can still declare him hostile and cross-examine him. And he can still be brought. He could have still been brought to his original version, as stated in the previous statement. Right? We are on technically, not on the merit of the case. Now, session judge was helpless. He could not do anything.
Therefore, Lordship,
In the chief, he said they are
about their presence.
present. Next day, cross after 2 months, he said, I don't know.
He said, I depose under the influence of liquor.
Aha. Interesting turn of events. I think wife
yes,
Wife died.
And he
But
was.
the man still changed his position in the cross. Interesting one.
And he was there in the entire night, for the entire night, along with the body of his wife, but he did not raise any hue and cry. That also has to be seen. In his conduct.
We are not on the
That's
acquittal
right.
or
Yes.
conviction, but the way the trial was conducted and what are the handicaps. It should be fair to both. It should be fair to both. Prosecution, it should be fair to the prosecution also.
In my case, actually, it affects both state bus by accused, both.
Next Friday.
20th.
20.
20.
Huh?
Deeply obliged, my lords.
Item number 3.
Main to direction.
May I please, Your Worship? Kindly see the last order in the appeal.
Last order in the appeal.
Manner, because actually it's out to have in the.
Oh, service report.
Well,
Service completed, my lord. There is a report. Provided, my lord.
Okay. Heard Mr. A.K. Hussain, Learned Counsel for the Appellant, and MS Mr. K. Bush,
My lord.
Learned Additional Public Prosecutor for the respondent number 1, Command State of Assam. Also, Para, Mr. Bush, Learned Additional Public Prosecutor. Has, comma, on the basis of a report of the in charge Zagon Police Outpost, Police Station Lekhapani, dated 27/6/2024, comma, has submitted that as per the said report, notice has been duly served upon the respondent number 2. Full stop. A photocopy to that effect has been placed by Mr. Bush. Full stop. Para. In view of the above submission made by Mr. Bush, Learned Counsel for the Learned Additional Public Prosecutor, comma, service of notice upon the respondent number 2 is treated to be complete. Full stop. Yes. And first go or second go?
Lordship, ground. My lord,
I don't
the
think
ground
there is ground. I don't think there is ground.
Yes, my
Is
lord.
there any ground?
Yes, my lord. Official ground, my lord. Not made for-
Official ground. Let us see.
My lord, your lordship, see annexure, see my lord. In page number 39.
Legal and examined by corresponding
Regarding Zail appeal. This letter is sent from Srimati Sagarika Borpujari, Secretary, District Legal Service Authority, Sibsagar, to the Honorable Secretary, High Court Legal Service Committee. And
no, not High Court. District. Which one? Page?
Annexure C, page number 39. 39.
This is in July.
15th of July. 15th July, 2024. Here, you have
It is, I think, if you read page 38,
38, page number.
then the delay
Yes, my lord.
occurred at the end of the District Legal Service Authority, Sibsagar, perhaps.
Yes, my lord.
Uh,
I'm going through the 38, my lord, page number, yeah, 39, my lord.
no, yeah, that delay. What is the when is the judgment?
Judgment is, my lord, in the
Hey, delay.
judgment and order dated 29/10/2022.
MS Begum, come to page 9.
Page number?
Page 9.
Yes, my lord. Yes, my lord.
Date of judgment and date of sentence is 29/10/2022.
Yes, my
Right. Come to page 38.
Yes, my lord. Petition of.
Immediately thereafter, the superintendent district jail wrote to the district legal service authority secretary on 3rd November 2022.
Yes, my lord.
Right.
Yes, my lord.
For favor of kind disposal.
Yes, my
Meaning
lord.
thereby
Yes, my
to
lord.
prefer an appeal. Now see on from 3rd November, kindly turn to next page.
Yes. 39, Annex C.
Oh, there is a reason.
Here is a
Ah.
letter. I have the honor to state that on 12/7/2024, during shifting related works, a bundle of jail appeal was found, which were kept ready but not sent to the High Court Legal Service Committee. The matter has been already informed to the Honorable Chairman, DLSA, Sibsagar, to take necessary action on the.
A very good ground. Will not put to notice. No? No? Heard MS BRA Sultana, learned legal aid counsel for the accused appellant, and MS A Begum, learned additional public prosecutor for the opposite party number 1, State of Assam. Full stop. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation or delay, condonation of the period of delay, which is stated to have occurred in preferring, in filing the accompanying criminal appeal. Full stop. The applicant as the appellant, comma, has preferred the accompanying appeal to assail a judgment and order dated 29/10/2022 passed by the Court of Learned Additional Session Judge, come special judge, within bracket POXO. এইটো আমাৰ ইয়াৰ হোৱা নাই, নিজৰ হোৱা নাই, legal service ঘটনা কৰিলে।
Please, your lordship.
হা? কি এইটো? Oh, oh. 6. Yes.
Well, this interlocutory application,
1/4 of the earlier one.
well,
1/4 of the earlier one.
yes, well, exactly.
1/4.
1/4,
So it deserves consideration.
yes. And
What do you say?
there is a same ground,
Same ground.
near about same ground, because after the passing of the judgment, my lord,
Huh.
Kali peruse the 44th page, the applicant
Huh.
filed an application before the superintendent of jail.
When is the judgment?
My lord,
When is the judgment? Please tell me.
judgment on 17/2/2024,
17/2/2022. Conviction.
conviction. for
Offense.
life, 302.
302. Okay.
Then on 25/2/2024, the applicant submitted an application before the superintendent of jail for assistance. My lord. Then the superintendent of jail on 3/1/2024 forwarded the same to the district legal service.
1/3/2024.
1/3/2024, page 44. Ma'am.
Gulaghat.
Yes.
Gulaghat.
Yes. Then there was some delay, my lord, and on 24/7/2024, the
Ah.
same was communicated to the legal service committee.
I have
of
honored
this
to
honorable
forward your
court.
phone number. Jamita by forward by your sons of India, please, but legal or kind request for legal assistance too. Your serial number?
My lord,
Yours?
serial number, first one, my lord, Sri Gangu Tati.
Gangu Tati.
Yes.
You are legal counsel?
Yes.
Okay. Yes. Heard Mr. R. Islam, learned legal aid counsel for the applicant, appellant. And MS A. Begum, learned additional public prosecutor for the opposite party. State of Assam. First of আগৰটো নিচিনাই হ'ব প্ৰথম পাৰ্টটো লিখক চেঞ্জ কৰক 302 প্ৰথম লিখক হেৰি judgment and order dated 17/2/2024. Court of Learned Sessions Judge Gulaghat. Sessions case number 4/2023. Convicted under section 302 IPC. Sentence. Rigorous imprisonment for life and to pay a fine of rupees 10,000 in default of payment of fine, simple imprisonment for another year. Delay 133 days. বাকি section 5 limitation এবোৰ লিখিব ডে কেইটা ফিল আপ কৰিব লাষ্টৰ পেৰাটো ঠিকে থাকিব খালি 133 days হ'ব আৰু লিখক it transfers from annexer
B, my lord. Page 4.
B that the same is a communication from the Superintendent District Jail Gulaghat to the Secretary District Legal Services Authority Gulaghat to prefer an appeal before the appellate court on behalf of the applicant appellant. Full stop. The said communication was made on 1/3/2024. Full stop. It transfers from the communication dated 24/7/2024, appended to the instant application as Annexer C and addressed to the Secretary High Court, Guwahati High Court Legal Services Committee by the Secretary Legal Services Authority Gulaghat, that the necessary case papers along with the certified copies of the documents were forwarded to forwarded only on 24/7/2020. Full stop. I can লিখে দিব last para to.
Much obliged.
Just 7 and 8 for hearing.
এটা হলো হেৰি 302 তারপর পার্টিসিপেট এই পার্টিসিপেটর লাইন লিখিব দেই এটুত পার্টিসিপেটর লাইন লিখিব পক্ষ টক্ষ নহয় এটুত 302
May I please your lordship?
Hmm.
There is some difficulties, lordship, as he has went to see a doctor, lordship, for his
Huh?
son. He went to a doctor to see for his son, lordship.
Okay.
So,
Yes,
lordship,
Mr. Sharma. Are you ready? Yes, madam.
I'm ready, but in the second half, I have got some personal difficulty, your lordship. First half, if you lordship. It's a.
কিমান আছে? আমার কিমান আছে? কিমান আছে? Maybe. Okay, you can, I'll just start, that's the start. If not possible, we'll adjourn.
Lordship, I may permitted to look every 3 o'clock, my lord, not before.
3 o'clock.
After the
You,
next-
you will leave the court 3 o'clock?
Yes.
Let us make it happen. দুটা appeal to দুটা appeal. দুটা appeal. Similarly situated? Similarly situated, let him.
But
There, I'll not think that there will be separate line of arguments or something more in case of
Only
one.
in case of the other accused, there's one point, one of the witness who had said he had given alibi that actually he was a prosecution witness. Then he went and he became a hostile witness and he was called as defendant witness.
Yes, madam, is it permitted or not?
But that evidence was not taken into record by
One
the,
case, your lordship,
That I got the answer. I'll give you.
my lord,
I'll give you that,
they are not
That-
allowed to
that-
cross-examine in
no,
the
no, no, that,
previous statement,
search sheeted, in the search sheet,
my lord,
X is a listed witness
my lord.
along with others. But prosecution during the trial did not call him. Right? Then when the turn for the defense came,
Yes,
defense called him as a witness.
yes,
I think that was
yes, my lord.
that was a question from my end. Thus, there will be second part.
My lord,
That I think Zaid Kamar was there.
yes,
That answer is, it is permissible.
but they cannot,
Now, next question, I don't know.
yes. No, they are
But the
not-
first answer I have got,
They
that
are- they
it
can-
is permissible to call them as a witness.
Witness as a defense witness, yes,
I don't know the second part. Yes, prosecution is, to that extent, I know,
my lord.
prosecution is allowed to cross-examine. Can is permitted. I don't know the third one.
As regards
Whether
this-
since
they
he
can-
is a listed witness and his statement under section 161 has been recorded, whether prosecution
They
can,
can-
while
They
cross-examining,
have found that
Huh?
time, my lord.
you give it to me,
My
I
lord,
want to know the answer.
just
wait,
one line was
Because
there.
it is in existence.
My lord.
Whether he can be confronted with the,
Yes,
because,
previous statement,
yes, because there is no restriction in cross-examining
yes.
otherwise.
My lord.
One can go here. He can ask the question whether sun revolves around the moon or moon revolves around. You can ask.
My lord.
It is another thing that judge will stop you. But you can ask, there is no limitation. So why previous statement cannot be confronted? Not in your case. Why cannot be confronted? That is my question. See, in the evidence side, there is no limit to the cross-examination.
Lordship,
Prosecution has become free.
my lord,
Now he becomes the
my
cross-examiner.
lord,
That something is in existence.
lordship,
Why prosecution cannot test him about his credibility or to demolish his credibility with a previous statement already in existence, which has been supplied also at the stage of 207. This is my question. I don't know the answer. I have to formulate the answer if no answer is there. But first part is there.
lordship.
It is in existence
I know.
and it is circulated at the stage of 207. Both of them received. Now, if he say it goes to moon,
And-
why don't the prosecution in reference to the previous statement cannot bring him to the earth? Am I clear?
Lordship,
What is the restriction?
my lord.
There is no restriction in the Evidence Act. Something you please try to
Only
make
one
it.
judgment we have found, that was given by Mr. B. M. Chaudhary, Lordship, AN 67 or 67 criminal law. I'll just
Okay,
try to
okay,
find
take your
out.
time, take your time, and it is not related to this case anyway. But those answers I have found. Now the only question is, this witness is called by the defense. His previous statement is already on record, whatever. Circulate also at the stage of 207, right? Now, so here is a previous statement. Now, he coming in that case, the defense witnesses, they projected a different story, right? Despite existence of 161 statements. Why not the prosecution as a cross-examiner can demolish his credibility in reference to,
161 step.
in view of section 157 of the Evidence Act? Demolish him,
Lordship,
then defense case is gone.
I know.
Okay.
Lordship, in the instant case, what has happened, the witness had, in the instant case, the witness has given evidence as a prosecution witness and he was cross-examined by the,
That is a difference again.
then he again was called as a defense witness. And actually in under 233, the loaded trial court ought not to have permitted, under 233, he
Okay,
ought not
let's-
to have allowed.
Let us see. This is
To
new
give
one.
defense
I don't
witness.
know the answer.
There is a
233.
judgment to that
Ah.
effect.
Good.
But since he has now been allowed, after allowing him to give statement and cross-examine, then what's the situation is another thing. Here, what the
233, let me read 233 first. No, this is an interesting one. 233. Judge is not acquitted. He shall be called
entering upon defense.
Subsection 3.
Yes.
Okay.
So
What
under,
is the judgment?
yes, there is a Madhya Pradesh High Court judgment.
Interesting.
I have just one copy.
I'll give it back
No,
to you. Put Korea, you. Huh? He is gone. Paragraph.
I think 11 is written. 11.
Marked. This one.
Yes. I have copies.
Okay.
But now he was called,
Not quit also.
I have another
Huh?
fair copy for your lordship. I have.
I will read you.
Lordship the judgment. You Chaudhary, AI 1968 SC 1390.
লিখি দাও তো, একটু লিখি দাও। Very good. কালি একদম দেরি করবো লাগিব, চাব লাগিব, রেকর্ডটা খুলবো, ইউপিএস রিপোর্ট ওটা করে দেবো।
Just one line.
একটু কালি যাবো, বুঝতে হবে। Engagement,
390.
engagement to এটা ধরনের সিচুয়েশন পাবো। Raise 82.
Found lying on roadside of Burhanpur Road, Brahmapur Road.
10:45 a.m. 10:45 a.m. in present. Found lying on the roadside
Yes.
on 20,
3-1
23-1.
by committing suicide.
And this is in reference to what? UD case. Huh?
No.
Ah.
FIR was lost.
No, he has said, last line,
Hmm.
as reported by police UD case. There may be something
That
more. Initially reported maybe as a, whatever, unnatural death case.
and
If the family members themselves reported an unnatural death case, is there any delay in lodging the FIR?
yes, 16 hours delay. The entire night there was no.
Find out from the case record whether any UD case is already there. Anything UD?
How much he has checked, madam, sorry.
No.
Here, evidence of PWT, I found some anomaly, my lord, at page 32. Second line, date, my lord, 10/7/2006, date of occurrence is 24/1/2018, 23/1/2018.
I meant to sound. Second line,
Yes,
10/7. Original,
this signature is there,
right? Maybe typographical,
or maybe.
maybe in the
But
original,
postmortem or is postmortem is of that, it tallies.
then maybe it is typographical. 24/9/2018 is Chalan. It is at 4 a.m. Vimal Hoikia. Dead body Chalan is at
That's been exhibited.
4
please exhibit.
a.m. on 24/9/2018. When is the inquest?
Inquest,
Inquest is 10:45
yes, ma'am.
a.m.
Date is 24/1/18.
24/1/2018. Then dead body. Where he conducted the inquest? Any idea? PO, index of PO. Push it. medical, where the postmortem was done? Postmortem was done where? Which hospital? Hmm? Not Lakhimpur.
His address is given.
Postmortem was done on 24/01/2018.
15
So that is perhaps,
typographic.
that can be, if we see the original, that can be ignored, but inquest is 4 a.m. Postmortem at 3:40 p.m.
Report to PM.
There the inquest, it is said place where dead body. Was found.
Lordship, evidence of PW 11.
It looks like,
My lord.
just because inquest was found,
Yes.
but from the dead body challan, dead body challan was date of hour and dispatch and distance from the postmortem. Date of this time of dispatch is 4 a.m. on 24/01/2018. Marks on the dead body as per inquest report. So inquest report should have preceded the dead body challan,
Yes.
right?
Yes.
But dead body challan was also prepared, sorry, inquest was prepared at 10:45 a.m. on 24/1/2018. Postmortem was done at 3:40 p.m. on 24/1/2018. The things are not matching or falling into places. When the incident had occurred?
3/1/18.
20. And when the police was informed at very first point of time?
That's right. However, PW4 says, on coming to know, between that time he immediately telephoned the police. But after that, what happened? The police immediately came or they came on the next day. But the PO himself the evidence says that he came on 20.
But the seizure list was conspicuously on 23rd January 2018 at 11:20 p.m. So this man was there. Seizure list called. ঘটনা যদি 23rd হয় evening hours বা night 8টা বাজে ধরিল, then seizure was made at 11:20 p.m. on 23rd January. তার মানে 3 ঘন্টা পিছু। One knife was seized, right? Thereafter, but they are not concerned with the body till that time. 11:20 they seized the knife, but dead body they are not concerned. At morning 4 o'clock they send the dead body, and as per the dead body challan, injury as per the inquest report, but inquest report says it succeeded dead body challan 10:45 a.m. on 23rd. FIR at what time? What is the form? What is the form? Page 1 form, time. But form is not here.
You join us.
Seizure list 11:20. Information received is also 11.
GD.
Huh?
GD was there.
That is what I am trying to find out.
It's not on record. Asan I didn't find it.
Is there a song? Yes,
GD
right.
was 6:45.
GT to it, can I get GT?
Or 24 one, no?
Yes, very true.
Hopefully it's.
Uh-huh.
I don't know, by protocol.
You were arrested when? Twenty-four forwarded, 10:30 a.m. before lodging the affair. Huh? Yes, arrest memo 10:30 a.m. on 24 January. But FIR and information received time was 11:20 a.m. So arrest preceded the FIR. Huh? Huh? Arrest memo of arrest. Memo of arrest. এখন original, এখন
Lordship has found the GD.
এইটো হেৰি inspection memo এখন memo of arrest. এখন memo of arrest. ৰাতিপুৱা 10:30 a.m. memo of arrest. And information received date is 11:20 a.m. Arrest আগত. Information পিছত. কিন্তু seizure আৰু আগত. Huh? Something is fishy. Prayer for twist. Commands are even to be carried by the police officer. Challan for use when dead body. at the roadside. First PR. There is one circle inspector note. The brief of the case is that on the DR, I don't know, date of I was saying. On the date of DR, Rumi Hazuka is a complainant.
Rumi Hajoria.
Rumi, the complainant, lodged
Rumi Saikia.
Rumi Saikia, Rumi Hazarika, Rumi Hazarika, wife of Bimal Saikia. Here he is writing. The brief of the case is that on the DR I don't know, date of reporting perhaps. We'll come to DR later on. Lodged an FIR at this PS to the effect that on 23/01/2018, at around 8:30 AM, the complainant husband Bimal Saikia went to shop for Ponsamik Pak. Then on the way, accused person wrongfully restrained the complainant husband and with a sharp weapon assaulted the complainant husband and murdered him. The public apprehended the accused persons
Hello.
and arrested them and handed over the police, hence the case. Now DR is, interestingly, 21st of January.
Lordship.
I don't know.
Lordship, and the time 8:30 AM or PM, my lord? 8:30, I have heard 8:30 AM.
Now on GD entry, 6:28,
Yes.
23rd January, 9:45 PM, night. সংবাদ পোৱা মতে এতিয়া ব্ৰহ্মপুৰ গাঁৱৰ চি নৱ শইকীয়াই ফোন কৰি নৱ শইকীয়া is what? Who?
Nobo Koikia. Nobo Koikia is not a PW.
No PW. জনাই যে ব্ৰহ্মপুৰ গাঁৱৰ এজন ল'ৰাই এজন ল'ৰাক ডেগাৰ মাৰি জখম কৰিছে আৰু জখমীজন সংকটজনক অৱস্থাত আছে মতে জনোৱাত পঞ্জিত দৰজ দি মই SI PD বুঢ়াগোহাঁই লগত ASI AK চৰকাৰ মনোজ হাজৰিকা আৰু সংঘীয় ষ্টাফ লগত লৈ ঘটনাস্থলী ব্ৰহ্মপুৰ গাঁৱলৈ ৰাওনা হলো। So there was a GD entry.
There was in IO's evidence it has come up on record.
A GD entry was brought? No.
He said along with the charge sheet, he has submitted the GD entry. In his evidence estate.
It is to be noted that
Oh. Yes.
10 PM entry in a case diary.
Hello.
After 9:45 GD entry, he went to the PO. Dead body lying at the village road. And one accused person, Ipom Bhukan, has been apprehended by the villagers. And he's being assaulted by them. And as the situation is going worst, I'm ready to remove the dead body from the place and also to take custody of the accused who has been apprehended by the public. Dead body. I take custody of the below noted apprehended accused person, Nipam Phukan, at 10:40. Is there any witness by Putu Soikia?
Yeah, yes. PW3, brother. Time period also differs, my lord. The story says from from torchlight they have seen the accused person. So if it is AM, my lord, then there won't be any dark.
No, PM, it is PM.
No circle officers, no
Circle Inspector, he's in
AM.
AM 21st January. I don't know what. Yes. Let us proceed then. What has been brought on record? Rumi Soikia is the informant. Hmm.
From a shop, the accused person confronted my husband in front of the entry of the house. Then he assaulted him with a sharp weapon and thereby killed him. It was apprehended the accused person at the place of appearance and assaulted him and then handed the officer. Therefore, charge sheet was filed. It was committed. There against around 11 witnesses.
Since we have seen the documents of straightway come to the IO first, then we'll see the other prosecution witness. Yes.
I was serving as OCA Narayan PS and on that day, one sweet movie center lodged Jahar at the same PS, which was registered by me by Narayan police case number 29 under section 334 of the IPC. And I myself pick up the exhibit 1 is the same Jahar lodged by the informant, exhibit 1 is the signature. This will be the form of the FIR. And exhibit 1 is I with since signature thereon. Thereafter, I went to the place of occurrence, recorded the statement of the informant, the section 161 of the CR. I found the disease in deadline sufficient
Case of occurrence, I contacted inquest on the dead body. He was landed executive magistrate at the circle of the in presence of witnesses, and second officer, and Sai Patmandar, Mural. Exhibit 5 is a set witness report. Exhibit 5(1) is a signature of SI Patmandar. I sent the dead body for postmortem examination to the North African State Hospital and collected report thereon. I prepared a statement of the place of occurrence by Exhibit 6 and 6(1) is my signature thereon. Exhibit 7 is a challan for sending the body, sending the dead body for postmortem examination. 7(1) is my signature thereon. I examined the other witnesses from nearby, the place of occurrence, and recorded the statement after section 161. I see 1(9).
Where is that serial list?
375.
Noting the syllabus is being produced by Devashish Saikia, who is one of the prosecuting witness we have to find. IO has no form of, or he has not been there.
IO is not speaking the truth. FIR received on 24/1. Right? Then about this, I seized, then investigation started. I myself took up the investigation of the case. He was silent, anything done by him prior to the FIR. Then he said, so investigation started after FIR. Then I seized one knife. If we turn to page 75, seizure list. Seizure list. Seizure list. Seizure list. Exhibit. Seizure was done 11:20 p.m. on 23. He is not telling the events which occurred. Yes, re-entry, thereafter something can be proceeded with. But FIR may be lodged later on. There will be no irregularity. But suppression, yes, 11:20 p.m. case diary. Seizure. It is noted accused person sent to the PS and person. Now I do hereby. And this is not leading to discovery. Seizure.
Handed over by one of the prosecuting.
Hmm.
And Devashish Guru is prosecuted.
Related.
People matching of the.
और विद्या हो गया इजी है विटनेस দেখুৱাই দিয়া মতে পুলিচ জব্দ কৰে দেৱাশিষ শইকীয়া সিজার লিস্ট Yes, I hope.
What you say here, with the five, is the son of Peter two. And Peter two is the person who is supposed regarding the following line of information.
Okay, we'll come to that.
The condition of the LS client, the present of the witness. Take this and execute signature thereon. Finally, finding sufficient written on the section 324 guidance. I submitted start sheet. The same section of guidance. Exhibit A is the start sheet submitted by me and 8 months signature there. This process. The dead body was found near a bridge at a village road of Varan. The place of occurrence is about 5 kilometers from the police station. There is not available communication from the place of occurrence. I received the Azahar on 24/1/2018 at about 11 p.m. And as per the Azahar, the alleged incident occurred on 23/1/2018 at about 8:30 p.m. No explanation was given in the Azahar regarding the delay of about 15 hours, or I have not made any notes around regarding such delay in logical trial. I have submitted the expect copy of the TV along with the charge sheet. I have not recorded the statement of the writer of the Azahar. I have not seen the secret.
No GD entry. I have submitted extract copy of GD entry along with the search sheet. Nothing. It is not there. One sketch map, one seizure list, one PM examination report. Yes.
Informant did not state before me that the disease has been started as Morillo in and at that time she went to the place of occurrence. This witness also did not state before me that she saw her husband lying under the bridge, smeared with blood, and then with the help of the torchlight taken by her brother-in-law, Benendu had freed the tree. He saw the person being away from the place of occurrence. He also did not state before me that she called one police area, with the help of whom he and her brother-in-law brought out.
Yes.
Police area did not state before me that they brought out the dead body of the immediate demonstrated from the place of occurrence with their family. PW4 Business Area, Gambura, did not state before me that he went to the house of one Bilal Guru at 8 p.m. and at that time he was Province Area and Vida Babu went to the house of Sheikh Bilal Guru was starting and on the ask. He told his younger brother that the co-exists informed from the business area but inflicting and close with him. This witness also did not say before me that he came to know from the family member that the business did not get the not of the house and having the alleged according to the they were to say did not say before me that he could not presume that he had heard the sound of the accused person in the case of offense. He also did not say before me that the disease was lying under the bridge sustaining severe injuries on his person. Today, I have not seen the knife seized by me at the time of the investigation. I have not seen any article that seized by me. It's not a fact that I have not properly investigated the case and not finding sufficient information.
There see the injuries, doctor. PM report. abdomen away from midway right thigh.
At 11 p.m. If I was from 11:28.
This has not been explained by the prosecution. That regarding dead body may be forwarded if some dead body is found meeting some unnatural date. But seizure is not explained. Yes, what are the wounds? Stab wound, right hand abdomen. Abdomen. 2 inches away from inferior level.
That injury on the midway of right thigh. So there are two side injuries.
Right thigh anterior aspect, middle part. It is died due to shock and hemorrhage. There is also stage injury. 3 to 18 hours. Okay. Let us see the doctor evidence.
Ten.
Declined. Step. There is 3 step as per doctor.
This injury 1 and 3, I would submit the same.
Huh? Midway right thigh. Midway right thigh, okay. Clotted blood seen, okay. Stab injury on right side of abdomen. On iliacal level, away from 2 inches. Right side 2 inches. I think MS Bhuya, what do you say? Injury number 1 and 3 deposed by PW10.
But he
If we
mentioned
compare with the PM report, it looks like 1 and 3, one and the same.
same, my lord.
So basically 2 injury.
Right side, 2 inches away from the victim. Injuries,
CC Colita.
stab injury.
Doctor 3 to 18 months. Rigor mortis asset 3 to 18 months. Let us see now the substantive evidence.
One is the wife, the information. Page 94.
Death is homicidal, apparently. Now the connect. Let's see.
And the information. Actually, one is the exam that I have got and actually one is I know that the accused person who are present. This remote actually was my husband. Around 8:30 p.m. on 25th January 2018, the incident took place. On that day, my husband went to purchase little leaf from a nearby shop. At that time, the accused person under the influence of liquor were making nuisance on the road. My husband asked them to go to their home instead of making nuisance on the road. At that time, my husband called me as I am dying movie. I immediately went to the place of. So why I wanted to point the
Case map.
statement is that if you come from the evidence that her house is 500 meters away from the place of operation. So, I report other witnesses does not report that they have heard it, but they report that they have heard the accused shouting. But there was no evidence to the effect that the victim followed the name of his wife. I'm dying. So there is no evidence to that. She is the only one who reports that, and she goes running 500 meters to the place of operation. And whether she was the first person to do this thing, I'm not.
Are you aware of the concept of telepathy? Telepathy. Yes.
I immediately went to the place of occurrence and found my husband lying in a pool of blood under the bridge. When my brother-in-law, the brother of my husband, who was take care,
He is PW.
see,
Hmm.
he of the two,
Hmm.
who accompanied me, flashed the torch, he carried with him, the accused person fled from the place of occurrence. With my husband in that condition, my brother-in-law and I thought that my husband was alive. As my brother-in-law and I could not lift my husband from that state, I went to the place of Purik Saikya, SPW2,
Hmm.
in a run and found him to the place of occurrence. After arrival of Purik Saikya, we somehow managed to reach my husband's dead body
Hmm.
to the road from under the bridge on a Sunday.
Hmm.
In the meantime, many people gathered at the place of occurrence. And I asked him as to who had committed the incident.
Hmm.
My husband replied that the accused person died and the principal and the principal had committed the same incident. Half an hour after that, my husband passed away.
Hmm. It is dead body talking or live body talking?
That's what I will point out. Reading it in the book too. That means after coming back from the house of Pilgrim 2, there was no occasion for the victim to speak with Pilgrim 1. If at all he had spoken, he must have spoken to Pilgrim 1 prior to Pilgrim 1 going to house of Pilgrim 2. If that be so, that means Pilgrim 1 had the knowledge at the time of informing Pilgrim 2. However, from the evidence of Pilgrim 2 come out that they had no knowledge.
We'll come back. Ah. No. No, somebody mentioned it.
It's a usual part of the incident. We had forgotten whether I said it for police or not, which person, the influence of Peter, when we see on the road. It's not a fact that I did not say for police, that my husband, I asked both the accused person to go instead of being influenced on the road. It is not a fact that I did not say for police, that at the time when husband called me, I was dying moving, and that I went to the place of occurrence around. It's not a fact that I did not say before police at the time my husband was lying under a bridge in the of the blood. It is not a fact that I did not say to the police that when my brother-in-law is to accompany me, flashed the torch and carried me. The 18% died from the place of the It is not a fact that I did not say to the police that seeing my husband in that condition, my brother-in-law and I tried to lift him from there, but could not do so, and that's why I went to the house of police again and all these after arrival of the police, we got my husband to the road from under the bridge. It is not a fact that I did not say to the police. That in the meantime, many people gathered. At the time of incident, many people were at the place of occurrence. My husband was lying at one end of the bridge. It is not a fact today. I don't post policy for the report. The latest person to which they is not happening. It is not a fact that we have to follow the I know the informant. She is a relative of mine. I also knew she is I also know both the accused. Around 8:30 p.m. on 51st January, the incident is At that time, informant Rumi came to my house in a run and informed me that someone had been taken back injuries to her. Which is someone that in that time she had no knowledge. Immediately, I, along with the informant, went to the place of occurrence, found the informant's husband, most secure, lying in a morbid state, almost physical condition is not, that he's almost in a state of under the bridge. At that time, informant Rumi Sekia, Sutu Sekia, the younger brother Disease, Vimal Sekia, and I were present at the place of fire. Along with that, some villagers were there. Seeing injured Vimal in that condition, I asked to what happened. Whereupon he replied that Vita and Virai, that is the accused person of this case, nearly Nikon and Prabhu, inflicted an injury to him with a bike knife. Seeing the condition of the victim critical, we immediately lifted the still body of the victim to the road from under the view to the head of the cinema. At that time, the injured person was alive. But about half an hour after that, injured Vimal Sekia succumbed to the injury. And I asked the injured as to why the accused person had assaulted him. I came to learn from the injured that after having leave, he went to the road to get some getting leave. That the accused person under the influence of alcohol were making nuisance on the road. And that as he asked him to go to their home instead of making nuisance on the road, the accused person inflicted previous injury to Vimal Sekia with the knife, which led him to such a condition. It is questioning me regarding the incident. As per my knowledge, police seized the knife that was used in committing the incident. I saw that that knife, and today I have seen the knife in the court along with the matchbox. Police seized the knife and the matchbox from Piraj. I saw the knife stained with blood. With medical state condition, was it mentally fit to the course or not? We have to examine that. This comes between critical and not secondly, but someone has inflicted injury. And this part, the second part where he says, whereas you do one says, defeat the dead body. Second part whether there is some condition. Okay. When the informant came to my house, he told me that someone had inflicted injury to her. The time of incident, I was at my house. Before telling me about the incident by victim Vimal Sekia, I did not know who had committed the incident. Police recovered the knife upon making a search. I did not state before police the names of the people who were present in the case. It is not a fact that I did not state before police the scene the condition of the people. We immediately lifted the still body of the victim from under the bridge with the help of the Sila. It is not a fact that I did not state before police yet about half an hour after that, the injured passed away. It is not a fact that I did not state before police that I came to know from the injured that after having me, the injured went to get some treatment. The accused person under the influence of alcohol were making nuisance of the road. And that as Vimal Sekia, since asked them to go to their home, so the accused person yes, the informant is my relative. It's not a fact. It is not a fact that today I have reports falsely in the court. That the accused disease Vimal Sekia. It is not a fact that I have produced falsely. The informant is my relative or not. If you come later, it is his brother.
Brother, own brother.
Home of first cousin is not there, but it's we don't be. Five will say that you know, Dudu is the brother of the.
Okay. Any kind of enmity with the accused? Nothing. No suggestion.
But even if we take the prosecution, the evidence on the face of it, then also we are sensitive it is a sudden fight. We don't need to. Yes, we can. The informant is my sister-in-law. This is Vimal Sekia was my elder brother. I know the accused person. The incident took place around 4-5 months ago. Around 8 p.m. on the day of afternoon. After returning from my work, I took my meal and was about to sleep. Then I heard the informant started addressing me. When I got up and came out of the house, my sister-in-law informed me that something had happened to my elder brother. Then at that time my sister-in-law and I went towards the place of occurrence. When I fled the torchlight, I saw the accused person fleeing away from the place of occurrence. This is the presence of the accused. I saw my elder brother lying beside the road near the bridge in a pool of blood. On being asked, my elder brother replied that the accused person, Pita and Vida, inflicted grievous injury to him with a knife. Police question, police see the knife and a matchbox in connection with the incident. Today I have seen the knife and a matchbox. Approximately the place of occurrence is about half a kilometer away from our house. Worship and the informant stays near PO2 chief. The PO and the distance is half 500 meters. I came to know about the incident. I had not seen as to who had committed the incident. I saw my elder brother lying on the road near the bridge. The logic here, saw my elder brother lying on the road near the bridge. Everyone is saying the victim was lying under the bridge, not on the road. Houses of 4-5 persons are there near the place of occurrence, and the houses are Krishna Gandhi, Koharati, Lakshmi Kumar, and Monica. At first, I reached near my elder brother. I saw the seized articles in the hands of police. I saw the seized articles from the police were bringing the seized articles from the police. Today, I have seen that the knife in the court is not a fact that I had produced false evidence against the accused person for the sake of it's not a fact that today I have produced false evidence in the court that my elder brother told me that the accused person was assaulted. When I reached there, my elder brother told me the facts in a broken voice. It is not a fact that today I have been positive. Before these, one of the seizure. I know the informant. He is a resident of our line. I know the accused person who are present. They hail from a neighboring village. I also knew this is Vimosa. He was the husband of the informant. The incident took place last January. Around 8 p.m. I went to the house of my friends, Dunal Dubai. While I was sitting in the house of Dunal Dubai, the accused person present here, Provin Scott, Elias Dubai, came in shouting and entered the house of Dunal Dubai. On being asked as what has happened, he replied that his younger brother, that is the accused of this case, Nikon Shukon, had killed Vimol Setia with a knife. He also informed us that accused Nikon had killed Vimol Setia under a bridge. I immediately informed the PS about the incident and then went to the place of occurrence. When I reached the place of occurrence, I saw the dead body of Vimol Setia being kept on the road after lifting it from the bridge. I saw marks of injury caused with a sharp weapon and blood near the stomach of Vimol Setia. As per the information received from the family members of Vimol, he went to get veterinary and upon his return, the said incident took place. I saw accused Nikon being kept tied by puppy near the place of occurrence. Police seized a knife from the backside of the house of the accused Nikon, which I had seen in the court today, and the matchbox which I had seen today was lying beside the knife. Exhibit 2 is a scissor list, which police prepared at the time of seizure, and exhibit 51 is exhibit 1, which I have seen in the court today, is the knife along with the matchbox.
How is the seizure list? 75. Madam Bhuya, What kind of seizure is not, no description, how long it is? One knife.
One knife with cover plastic approximate. May I see the original? Madam?
Original I have seen. Looking at it, I am asking, what kind of approximate, approx, APROX, full stop, long,
Of ounce along.
null of some overwriting, ounce, along with one matches. No description. Pululi something that 27. Knife is everywhere.
But with
Knife
this
is everywhere.
white colored knife. But it doesn't
One
say
knife
so.
with cover,
Generally, all knives do not have
plastic,
the cover. Plastic.
along with so and so. Nothing about bloodstain. Somebody said bloodstain.
White color, about the white
Somebody
color.
said bloodstain, if I remember correctly. I saw the knife stained with blood. This is PW2. But he was not a seizure witness. But here, nothing about bloodstain.
But bloodstain, one of the witnesses have seen.
PW2, last line. Last line, he was not a seizure witness, however. He saw the knife today in the court.
Yes.
I have seen the knife in the court. Hey. Along with a matchbox. Police seized a knife and a matchbox from the Pirali. I saw the knife stained with blood. But he was not a seizure witness. But in the seizure list, no description regarding bloodstain. And no description about the knife. At least we normally see the length of the, at least the sharp part.
Yes.
There is nothing. Yes.
There witnesses have been saying that the witness will recover from place of occurrence or penalty. There's some contradictions. The season is what has been stated actually is that like he's been.
Debasis. Already said by Sharma.
I did not ignore the incident. I did not see as to who had been demolished second house. When it is proving came to us, I did not see blood striking on his body.
This is PW4. Okay.
It is proving came to us, I did not see blood striking on his body. It is not a fact that I did not say before police that it came and went to the house of my principal. That while I was in the house of accused person wasn't there. Here, the way to come, the blood came in sharply into the house of the where we had that only asked as to what had happened, he replied that his younger brother, that is accused of this case in front of his skin, with a knife, and that he had also informed us that it was home, it was the under the bridge. It is not a fact that I did not say it was only the letter went to get some written up. The incident is way back. It is not a fact that I should say it was only that I so if you become type of it. It is not a fact that here I had falsely that if you become being denounced. It is not a fact that today I have proposed falsely that it will become me about this. This is not read over the Caesar list to me. No knife or matchbox was recovered from the face of this possible. It's not a fact that the knife and the matchbox which I see in the court are not the ones that is seen at the time of this. It is not a fact that today I am reduced false pregnant. Fine. His name is Devashish Shakya. His father's name is Pradeep Shakya, who is PW2. I know the informant. I know the accused person who are present. I know that this is Vinod Shakya. The incident took place last January, around 8:30 p.m. in the night of the incident. I was reading in my house. Then I heard commotions from my house that took place outside of the house. I heard someone making noise under the influence of alcohol. When I heard the voices, I assume the voices were the accused person, but he doesn't hear the victim calling out his wife. After some time, I heard Sweet Jimmy Shakya, the wife of the deceased, Vinod Shakya, went shouting repeatedly along the road as my husband has been assaulted. Later, I went near the bridge located in front of the gateway of our house and saw Vinod Shakya lying with multiple injuries under the bridge. At that time, Vinod was alive, and he told us that he died and police had assaulted him. Later, Vinod Shakya died on the way to hospital. Police sees a white granite with a cover and a matchbox on the place of populace and in exhibition is secret. And I give it to my signature there. I did not see who had assaulted Vinod Shakya. The distance from the bridge to our house is about 200 meters. At that time, it was dark under the bridge. Police questioned me. I did not say before police that I had heard someone making commotion on the road under the influence of. It is not a fact that I did not say before police that I'm hearing the voices. I think the voices were to get victims. Srimati Rumi Shakya, wife of the deceased, did not tell me as to who had assaulted her husband. It is not a fact that deceased Vinod Shakya was lying under the bridge with multiple injuries on his abdomen. But at the time, Vinod Shakya was alive. And that he told us repeatedly that Vinod Shakya and Govind Shakya had assaulted her.
Evidence.
This is not a fact.
Evidence. Yes.
This is Vinod Shakya, is my uncle's father's elder brother. It has come from here. Your Worship. Police did not read over the Caesar list to me. The knife and the matchbox were not found at the place of occurrence. It is not a fact that police did not recover the knife and the matchbox from the place of occurrence. It is not a fact that the accused were not involved with the incident, and that day I imposed falsely against the accused for the state of affairs. It's not a fact that this is not taken such an injury by falling down from the bridge under the influence of alcohol, and that later he passed away.
Yes.
The brother of the victim comes out from this cross-examination.
PW?
The brother of the victim comes out from this cross-examination because his father is Pradeep Shakya. And in his cross-examination at page 23, he says, Vinod Shakya is my uncle's father's elder brother.
No. Devashish Shakya.
Here is a witness, his
Pradeep Shakya.
father.
Father. And Pradeep Shakya is PW2.
Cross-examination that victim is my relative,
Ah.
but does not say that he is his brother.
Hmm.
From this PW 5 cross examination comes up, the PW is a brother. So PW 3, PW 2 are both brothers, and PW 1 is the wife. These three are the only person who are posing.
Let us see PW2. PW2 father of PW2 is Tulon Soikia. Father of PW3 is Seniram Soikia. So there may be cousin brothers, not direct brothers.
And PW 5 is the son of PW.
Hmm.
So PW 2, 3 are the brothers, 1 is wife. These three are the only one who are opposing as regards they are already.
Province Soikia. This Province Soikia is brother, PW6. Own brother. Own brother. Father is Tulon Soikia. And who is the father of Bimal Soikia? Seniram Soikia. Then Seniram Soikia. Now, Mr. Bimal Soikia's father is Seniram Soikia, right? PW2's father is Tulon Soikia. So he is not the cousin brother. PW3 is the own brother. So if PW3 is own brother, okay. Then PW2 is cousin brother, perhaps. So he's stating related is not that incorrect, not that incorrect.
PW 1, 2, and 3 all are interested.
Well, see to that related, okay. Your submission is that they are interested.
That I submit later. before the-
Yes.
Also, one thing comes up. you need to
Among
do
that,
in 5 houses, 200
then
meters.
they have Purnima Soikia. See. Yeah. Good. Just word present.
I know the informant. I also need his remote here. He was the husband of the informant. I know the accused person who are present. The incident took place about 3 months ago. It's now 8:30 PM on the day of incident. When I went to my house from my shop at Narayanpur, my wife's Srimati Munima Sekhar informed me that the accused Nippon Sekhar had dealt beggar go on the house. When the people were questioning about the accused person, I was present there. Accused person replied that accused woman had dealt a blow on the head of Nimrod with a piece of bamboo and also stabbed him with a knife. As a result, Nimrod succumbed to his injury. When it released in the night, that was seen for I was present there. When it released in the night, he was present. I put my signature in the list. At the time of the incident, I was not present at the place of occurrence. I had arrived at the place of occurrence half an hour after the occurrence. I did not see as to who had done the beggar court. No, I have not seen this beggar in the court today. I cannot say as to how the incident. Proveen had entered the door, whereas Proveen has gone to the house, he had got unit 4, and he has said the other person. Clearly 7. In Rupali family. Wife of Mr. Tanvi. I know the informant, it is Vimal Saikia was the husband of the informant. I know the accused person who are present. On one day at about 9 months ago, while I was sleeping, my elder sister, Gandhi Kanti, woke me up and informed me about the incident. I heard about the commotion after getting up from bed. After that, I went to the place of occurrence and found Vimal Saikia lying under near the road in a moribund state. At that time, many people gathered there. Later, Vimal Saikia was taken to the gateway of his house in a morbid state. After some time, Vimal Saikia passed away. From the family members of the disease, I came to know that the accused person presently had a sort of commotion. It is making me happy.
Yes.
Which cross-examinations, we say, I came to know about it from the family members of the and the 7th house is on the left-hand side of the road. And we look at Dalini Tanti. It is looking 9. She will report us looking 9. Her house is on the right-hand side of the road. I'm going to inform you. After leaving for deceased husband, Vimal Saikia, he was the husband of the informant. I know the accused person. One night about 19 months ago, while I was sitting in my house, I heard the sound of Vimal Saikia's wife shouting, as I am dying, he is dying from the bed. I immediately woke up and went to the place of occurrence, where I found Vimal Saikia lying on the road, with blood coming out of his body. He was in a morbid state. I screamed as to who had made the assault and reached the house of Secretary Budhan Saikia. Vimal Saikia's wife told me that the accused knew her. Vimal Saikia passed away half an hour.
Yes.
Fine. He is the husband of Illuminati 7. I know the informant. I knew her deceased husband, Vimal Saikia. I know the accused person. The incident took place around 9 months ago. Around 8:30 p.m. while I was watching TV in my house. The accused Proveen was also watching TV. As I was dozing while watching TV, Proveen left my house. After some time, while I was sleeping, I heard some screaming raised by the informant. And then I found that Proveen was not there in the room where the TV was kept. Thereafter, the informant called addressing me. Opening the door, I did not see anyone outside. After that, I heard a lot of commotion on the road, and I saw police coming to the place of conference. Later, I came to know that Vimal had died. The major said that Vimal had succumbed to the injuries caused by the
Already, medical we have seen already.
11.
Also seen.
See. 7 contradicts all the statement of only 1, 2, and
These are not contradiction.
May-
Neither defense has not made anything
Yes,
to bring contradiction. So far, you have to
the statement.
cross-examination. You have not done the part properly. We cannot read those as contradictions. We cannot read, it is not a fact. It remains in the realm of suggestion only. Nothing has been brought on record. So far as contradiction is concerned. So you have to satisfy yourself with the prosecution evidence and to demolish the case of the prosecution. You have not brought anything by cross-examination. They have not brought anything by cross-examination. It is not a fact, it is not cross-examination. Few things are there, one or two I have marked. It is not a fact I did not state before the police, that is not contradiction. Even if IO is confronted in that manner, that IO said, yes, he did not state. No. Direction. First, what are the principles? তার কিন্তু তার নাম তো নাই আকৌ পুলিচৰ যিটো চাওঁতে এই হওক সেইটো কিন্তু পুলিচে এইটোৰ পৰা এইটো আপোনাৰ ধৰক পুলিচটো এইটো সঁচা কৈছে মিছা কৈছে এইটো যে PW2 এইটোৰ নামটো কি PW আপোনাৰ ধৰক 9 PW9 9 নহয় PW seven, 8, 9. 9 and function. PW9 কয় সি প্ৰমোচন শুনিছে আৰু পুলিচ আহিলে সেইদিনাখন পুলিচ আহিছে পুলিচ আয়ো নকয় আকৌ মানে মই মানে এইটো ক'ব কৈছো যে মানে ইমান এনথুজিয়াষ্টিক হৈ গৈছে ষ্টৰি বনাওঁতে গৰ্বৰ কৰি পেলালে ষ্টৰি বনাওঁতে সঁচা কথাটো ক'ব লাগে সঁচা কথা নকয় তাৰমানে অলপ মিলাওঁতে মানে বেছি হৈ গ'ল দেখি ফেমাছ হৈ গ'ল গোটেই একো নালাগে এইটো কণ্ডিশ্যন You have to rely upon 233. What are the principles for accepting oral dying declaration? So let us come to the point straight away. We'll see to that. Otherwise, first, what are the principles? Is there any principle laid down in any document? Just we'll see that. We'll test that principle along with the evidence. Our view. This is dying declaration in general, right? Without separating oral dying declaration from written dying declaration. My query is very specific. What are the principles for acceptance of oral dying declaration? Right? Written dying declaration maybe sometimes by the doctor, neutral by the IO, maybe neutral or independent or unbiased. But for oral dying declaration, that is through the mouth of the witnesses who are related to the disease. I know the specific thing. This is in general, without distinguishing between oral or written.
Oral line declaration. There were 4 line declaration different concepts. Multiple.
Before going into testing those, what are the oral dying declaration? How to, when to accept, when not to accept, right? Then thereafter, when to accept, and if the witnesses through which the dying declaration, the making of dying declaration has come out, are related, right? Then after we can find out the facts of the case. But this is without distinguishing between oral or written, because 32 says statements written or verbal. So verbal. we are on Bhargal because all these witnesses, yes, this is not of much help. To the principles are laid down, but not 22.
Interested witness. Oral dying because three dying declaration is discovered by the court. Fourth was before the mother. Dying declaration four.
No, this is 22 is not principle.
From scale of the examine sir. Oral dying of interested before interested. 24, 25.
No, I know, I want to know the principle. This is dissecting the evidence. This is analyzing evaluation of in the facts of that case. Is there anything?
Para 19 onwards of the judgment, Kamal Kudal is our court's judgment, which has been affirmed by the learned, Honorable Supreme Court. The High Court, after reappreciation of the entire evidence, concurred with the reasons assigned by the trial court in its judgment and order holding the appellant herein guilty of the offense of murder. The High Court accepted the oral dying declaration to be true and trustworthy, said to have been made by the deceased to the PW2. We are of the view, having regard to the evidence on record, that High Court was justified in accepting the oral dying declaration made by the deceased before the PW2 as one reliable and inspiring confidence. The law regarding the nature, scope, and value as a piece of evidence of oral and written dying declaration is now fairly well settled by various judicial decisions of this court. And dying declaration, oral or written, before it could be relied upon, must pass a test of reliability, as it is a statement made in the absence of the accused, and there is no opportunity to the accused even to put it through the fire of cross-examination to test its genuinity or veracity. The court has therefore to subject it to close scrutiny. But once the court is satisfied that it is truthful version as to the circumstances in which the death resulted and the persons causing injuries, the law does not expect that there should be corroboration before it can be relied upon. However, if there are infirmities and the court does not find it safe to base any conclusion on it without some further evidence to support it, the question of corroboration arises. We may refer to one of decisions of this court in the case of Haikuzam Sauba Singh versus State of Manipur, 1999 8 SCC 458, wherein in para 3 this court observed as under an oral dying declaration, no doubt can form the basis of conviction, though the courts seek for corroboration as a rule of prudence. But before the said declaration can be acted upon, the court must be satisfied about the truthfulness of the same, and that the said declaration was made by the deceased while he was in a fit condition to make the statement. The dying declaration has to be taken as a whole, and the witness who deposes about such oral declaration to him must pass the scrutiny of reliability. The truth sits upon the lips of a dying man. The whole idea of accepting a statement in the name of dying declaration comes from the maxim nemo moriturus presmutur mentir, which means that a man will not meet his maker with a lie in his mouth. It is believed that when a man is at the point of death and when every expectation of this world is gone, it hushes away every motive of lying. In our view, the oral evidence of PW2, namely Hanu Khetrapal, is quite natural. On the day of occurrence, he was working in his agricultural field. His presence in his field could be said to be natural. There is no good reason to Hanu Khetrapal to come before a trial court and depose falsely against the accused person. It is not even the case of the accused appellant here in that Hanu Khetrapal had some acts to grind against him, including the other accused, co-accused, and therefore fabricated the entire story of an oral dying declaration. Besides the same, the oral dying declaration of the deceased made before Hanu Khetrapal stands corroborated with the medical evidence on record. The medical evidence on record would suggest that there were 75% burn injuries on the chest of the deceased. The burn injuries were suffered by the deceased as the accused persons are said to have poured hot lali, raw material used for preparing liquor. We also take notice of the fact that the appellant herein came to be arrested on 23rd.
These are facts of the case now.
Yes.
Basically, the oral dying declaration, at least, because this is an exception to hearsay evidence. somebody was saying something to somebody, that somebody is telling before the court. So it is a otherwise hearsay evidence, which is not admissible in evidence otherwise, normally. But an exception is made in case of dying declaration that truth lies on the lips of the person before his death on that basis. Now, in case of oral dying declaration, at least one condition is that utmost condition that he must be in a fit condition to say. Here, PW5 said this man was repeatedly. See his. No. PW5, see. PW5.
Hard shopping, so it.
See, last line, page 32. That at that time, Bimal Soikia was alive and he told us repeatedly, not once, twice, many times, repeatedly that Petal, Nipom, Probin, Biru had assaulted him. And few others says in a more advanced state. And few others said, PW1 said to PW2 that somebody assaulted her husband. But PW1 in evidence in chief said that that is not sure, when she was told. PW3 said at the very first point of time, and I was the first. And in fact, PW3 had gone on seeing the accused persons also. He ran to the place after being told by the informant, half kilometer, flashed the torch, saw the two accused running away. These are few facts emerging.
Then Monday, when
Oh, you believing?
Monday, when
That Mahajan case.
yes,
Ah.
your law should be delivering judgment.
Anything more from your side?
Second thing of argument is that it does not on the failure of it should, if at all the prosecution evidence is also proved.
What is the evidence quarrel?
Quarrel is something you want to, because you are the asking to.
No, see, it is a case of circumstantial evidence, not a case of direct evidence.
Even if you think that.
Now, where the quarrel?
Accused under the influence of liquor.
Trying to satisfy for the dying declaration that there is.
Yes, we want to know the dying declaration
Yes.
part. If the dying declaration issue,
That is because it is also, because you're not, here in after paragraph 24, from 24, they deal with the principles of how to deal with interested persons before whom all the dying declaration has been in 24. It says that it should, it's not that it cannot, condition cannot be under the the dying declaration is given before witness who are interested. However, it has to be more carefully scrutinized than other witnesses. Because there is a chance that they will be led by emotions. That's why the scrutiny has to be on a high level. So whether the evidence of there will be 1, 2, 3, 1, 2, and 3 form part of the same transaction. Even if proof, we have to see whether they form part of the same transaction or there is time gap.
Monday is going to be obligation. Absolutely, Paro fix going no more. Monday is going to be
Yes.
We on Tuesday. If that madam does not turn up again,
Oh, shit.
on 2 occasions she did not turn up
I know.
at proper time. Put it on Tuesday.
Oh, no, but it was-
R Sharma, amicus in 7, equal to amicus in 9, and B. Yeah, senior counsel, additional public prosecutor for the respondent state. List the cases on Tuesday.
No part heard, man.
We are here. If time permits, we'll take up.
Fine.
Affidavit not filed.
Yes, Your Lordship. I'm on behalf of respondent number 2 and 3, Your Lordship.
2 and 3.
Yes, Your Lordship.
State.
Yes, Your Lordship.
I got filed.
No, Your Lordship, we have not filed, Your Lordship. We need some more time, Your Lordship.
Hmm?
We need some more time to file our affidavit, Your Lordship.
Okay, High Court has filed.
Yes, Your Lordship.
Affidavit by respondent number 1 is filed.
Yes,
Yes,
I have
Your
filed in 23rd
Yes.
August.
Yes, state.
No, Your Lordship, we need some more time, Your Lordship, to file our affidavit.
Yes. On the court proceedings of the case pertaining to the Itanagar bench is conducted through remote video conferencing. Post of Mr. A.R. Gugoi, learned counsel for the petitioner, is present in person. Post of Mr. Muk
Why
Patil,
did I, Your Lordship?
learned senior counsel and standing counsel, Guwahati High Court, assisted by
Mukbang Pertin.
Mukok
Mukbang Pertin.
Mupam.
Mukbang, MUK. Yes.
MU?
Yes, sir.
MU?
MUKBANG.
MUK.
KBANG. BANG.
M Patil.
BANG.
M Patil, learned counsel for the respondent number 1. And Mr.
Why Riram, Your Lordship?
Y.
Riram, Your Lordship.
Can you spell out?
RIRAM.
RIRAM. Learned government advocate,
Yes, Your Lordship.
Arunachal Pradesh, has appeared through virtual mode. Full stop. Mr. Patil, learned senior counsel and standing counsel, Guwahati High Court, has submitted an affidavit in opposition on behalf of the respondent number 1 has already been filed. Full stop. Mr. So-and-so, learned a government advocate, Arunachal Pradesh, for the respondent number 2 and 3.
Yes, Your
How
Lordship.
much? How much?
4 weeks, Your Lordship.
4 weeks. Puja then has paid for and is granted 4 weeks time to file counter affidavit on behalf of the respondent number 2 and 3. First of list the case Puja Pishot after Puja.
Oblige, Your Lordship.
2810.
Yes, Your Lordship. Oblige, Your Lordship.
Principal seat matter, item number 1 for admission.
In this matter also, we have received the voluminous instruction from the last.
Voluminous
Yes,
instruction.
Lords. We need some time to file our evidence proportion with.
Hmm.
I understand that. But there was a statement of raising. Now, then my anxiety, if date may be fixed and my friend may be given a short time to fight it.
You want to file additional affidavit? You have done so. When?
We have received it on 21st of August.
It is not in the record perhaps. There is no office note. Okay. I heard Mr. P. Bharadwaj, learned counsel for the petitioner, and Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, learned standing counsel GHE for the respondents.
1, 2, and 3, Lords.
For the GHE for the respondent number 1, 2, and 3. Full stop. Mr. Bharadwaj, learned counsel for the petitioner, has submitted that an additional affidavit on behalf of the petitioner has been filed in the month of August 2024. But the same is not tagged with the record. So stop. Para. The registry to trace out the additional affidavit of the petitioner, stated to have been filed in August 2024, and to tag the same with the case record. Full stop. Mr. Sharma, learned counsel appearing for respondent 1, 2, and 3, has submitted that he has received the necessary instructions to file counter affidavit and has thus prayed for 3 weeks time to file the counter affidavit. First of the prayer so made by Mr. Sharma is allowed. Please the case. Did you give a date?
25th October.
Date lovely.
Item 2.
Since the bio, we had appeared. Later on, selection was unsuccessful.
So what to do? Are we pursuing? Are we pursuing? Okay, then let them file the affidavit.
So far as notes have recorded in the last order itself, respondent number 2, I am appearing on behalf of Ms. Harish Chaudhary, State Legal Services Authority. They have no role in this matter, and we were only requested to convey this order.
That pursuant to that, he is being allowed.
He conveyed it.
Now, who is the main respondent then?
Respondent number 3.
State.
3 and 1.
State, you should have brought him.
We have met for
Right. Today, before this court, because this court is but regular in single bench. Somebody from senior government advocate office. What to do that? We can postpone it for their appearance. Mr. B.M. Dekar, learned counsel for the petitioner, and Mr.
R. Chauhan.
R. Chauhan,
Yeah.
Learned Counsel representing MS R. H. Chaudhary, Learned Standing Counsel, Assam State Legal Services Authority, for the respondent number 2. Full stop. None has appeared for the respondent number 1, 2, and 4. Today on call. Full stop. Mr. Deka, Learned Counsel for the petitioner, submitted that copy of the writ petition was served in the office of the senior government advocate Assam prior to filing of the writ petition. So the name of learned government advocate Assam is reflected in the cause list. Where Mr. Deka, Learned Counsel for the petition, has submitted that pursuant to the order dated 30/8/2024, the petitioner was allowed to participate in the Bhaiva Bhuse. And accordingly, the petition appeared in the Bhaiva Bhuse. Full stop. Subsequently, the results of the Bhaiva Bhuse was declared by the respondent authorities. Any date?
I'm not sure.
Wherein the petition was declared unsuccessful, is found to be unsuccessful. Full stop. Be that as it may. Full stop. As the response from the respondent number 1, 2, 1, 3, and 4 is got filed. We'll put it after vacation. List the case on according to the 25.
Hearing item number 3.
Yes. Record wise. Huh?
4 years and 4.
What is the date?
23/5.
20?
23/5.
Where is that? Where is the document? Or anything where it is stated? When he was produced before the court? Care for judicial custody. 24/5, huh? 24. Narcotics had arrested. So he was produced before the court on 24/5. It appears that
23.
23 arrested, produced before the court on 24/5. Then date is to be counted from 24/5. Yes, madam.
Submit our written argument on Monday, Lordship. My senior is in Lex in code number 3, Lordship.
What written argument in this?
Relying upon judgment passed by the Apex Court, wrong incarceration militates the fundamental right of the Constitution. And accordingly, the petitioners were granted bail numerous cases of that, my lord. Even the Guwahati High Court applying for the same, any the party of
Not required when this court has already passed, this court will rely upon its own order. Not to rely upon coordinate bench, not required. Now only thing is that presence of Mr. Kyle. When? See, this is this first, taking up this bail application, I am sitting, I have cut short the division bench. Monday, good. Monday. Mr. Anand, learned counsel for the accused petition is present. On the prayer of Miss M. Deka. Mr. MS M. Deka, learned counsel, appearing from Mr. S.C. Kyle, learned special public prosecutor NCB, has sought listing of the case on Monday, on the ground that Mr. Kyle has some personal difficulty today. We cannot say that he is arguing somewhere and has sought listing of the case on another date as agreed to by the learned counsel for the parties. This is the case on Monday. Monday already. We put it on Tuesday.